Wills, estates, and probate. Losing a loved one is a sad and difficult time for family, relatives, and friends. In addition, those left behind must often figure out how to transfer or inherit property from the person who has just passed. Hi, I'm Shemeika Fox, your Santa Cruz Real Estate expert and personalized real estate concierge. And though this is a sad and tedious topic, it is also very important. In order to transfer or inherit property after someone passes, you may have to go to court in order to settle the estate. Not a fun process, but it could potentially be necessary. It is not always easy to tell whether you need to go to court or qualify to use a different procedure. This video will give you some general information to help you understand what your choices may be, but we still encourage you to always talk to an attorney to get specific answers about your situation, as every situation is different. What are the different ways an estate can be transferred after someone passes? It depends. There are some ways that do not involve going to probate court. Here are some common examples. If a particular asset, like a retirement plan, life insurance policy, real estate, or a bank account already has a named beneficiary, that asset goes to the beneficiary or beneficiaries if there are more than one, without going to court. If a house is owned by 2 or more people as joint tenants, the other owners have the right of survivorship, which means that they inherit the entire property in their name. Real estate sometimes can be transferred without court, with a transfer on death deed, also called a beneficiary deed. Property in living trust can be transferred without going to court. Any portions of the estate that can be transferred more informally will likely have to be dealt with in probate court. How the estate is dealt with will partly depend on whether the decedent died with a will or without one. So what is probate? Probate means that there is a court case that deals with the following: deciding if a will exists and is valid, figuring out who are the decedent's heirs or beneficiaries, figuring out how much the decedent's property is worth, taking care of the decedent's financial responsibilities, and transferring the decedent's property to the heirs or beneficiaries in a probate case. An executor, if there is a will, or an administrator, if there is no will, is appointed by the court as personal representative to collect the assets, pay the debts and expenses, and then distribute the remainder of the estate to the beneficiaries. Those who have the legal right to inherit, all under the supervision of the court. The entire case can take between 9 months to a year and a half, maybe sometimes even longer. Probate is the legal process that one must follow to transfer or inherit property after a person who owned the property has passed away. Depending on the amount and type of property the deceased person owned, you may or may not need to go to court to transfer or inherit the property. All of the property legally owned by the deceased person is called the person's estate. If you need to go to court, this is commonly called going through probate. A person's estate may need to go through probate even if they had a will. The best way to avoid probate is to create a trust in which your property is named, as well as the beneficiaries and trustees. And of course, if you would like me to connect you with a local reputable trust attorney to help with the details of your trust, give me a call and I will connect you. And if you want more information on wills, trusts, probates, and or real estate, hit that like and subscribe button for new videos that come out every week. The personal representative is the person responsible for representing the estate in the probate process. The personal representative collects all the property of the person that has passed, pays their bills, and then distributes any remaining property to the people with a legal right to receive the property, called heirs or beneficiaries. The property that a person leaves behind when they die is called the decedent's estate. Does the estate need to go through probate? Not all properties need to go through probate. To inherit property from someone who has passed away, you will first need to figure out what process you can use to transfer the property. Did the person who passed have a trust or a will, and can the estate bypass the probate process? If you find that the person who passed has left a trust and there are heirs to the trust, the estate may be able to settle outside of the court system. That would obviously be the preference. The first step in settling someone's estate is to figure out if there is a trust and or will, and figure out who the right person is to handle these matters. Who is the right person to handle probate matters? That's a really great question. Typically, the person named in the will or a close relative, if there is not a will to be found, 2 or more people can represent an estate together, but they must always act together. If the person had a will or trust, the person listed as in charge, often called an executor, will generally handle any probate. If they cannot or do not want to, then it will often be a relative. If the person did not have a will or trust, often a close relative will handle any probate. If the person was married when they died, their spouse is often the person. Or if they have an adult child or children, then an adult child will take over the case. Relatives should generally talk to each other to decide who and how decisions will be made for the estate. If the transfer of property needs to go through probate, a judge will appoint someone as a personal representative of the estate. The law gives preference, also called priority, to who this will be. This is often the person named in the will. If the person named in the will cannot act or there is no will, then there's an order of priority for who may be appointed a personal representative. The order of priority is any surviving spouse or domestic partner, then a child, then a grandchild, then a parent, and then a sibling. A judge will need to decide which person has priority. If someone was not named in a will, the person who died might have named them as a beneficiary, for example, on a retirement account or a bank account. These people may also have decisions to make or steps to take in order to claim the property. Another way to transfer real property is a non-probate transfer by revocable transfer on death deed, or TOD. What is California's transfer on death TOD deed? Since January of 2016, the passing of California Assembly Bill 139 has provided for the automatic transfer of ownership of residential real property upon the death of the owner without the need for probate if the owner recorded a revocable transfer of death deed, officially named the Revocable Transfer of Death Deed, or TOD deed. The deed directs that a beneficiary specified by the transfer will become the new owner of the property upon the transfer's death. Like a will or trust, a TOD deed is revocable, meaning the grantor, current property owner, can decide that a different beneficiary will be granted ownership of the property upon his or her death. The TOD deed does not alter the current record title of the property. The TOD deed provides the full names of the parties called beneficiaries who will receive the property upon death of the owner. Multiple beneficiaries may be named. New changes to the TOD deed as of 2022 based on California Probate Code 5600C, TOD deeds law is now in effect until January 1, 2032, unless a later statute deletes or extends that date. Under California Probate Code 5624, the TOD deed must be witnessed by 2 people who were present at the same time and who witnessed either the signing of the deed or the transfer's acknowledgement that the transfer had signed the TOD deed. If filing a new TOD deed, the updated California form effective January 1, 2022 should be used. How is the transfer on death deed prepared? The TOD deed must be recorded on or within 60 days of execution. The TOD deed will be deemed ineffective if it is not recorded in that time frame. An affidavit of death or other evidence of death is recorded when the owner dies, transferring the ownership of the named beneficiary. An affidavit of notice should be recorded stating that notice to non-beneficiary heirs of the decedent was given pursuant to Probate Code Section 5681. This can be recorded as a separate document, or a paragraph to this effect can be included in the affidavit of death. A change in ownership notice must accompany the evidence of death. Revoking a TOD deed is revocable by the property owner before death by one of the following 3 ways. 1, recording revocation of revocable transfer of death deed in the property owner's county of residence. A revocation of TOD deed must also be witnessed by 2 witnesses. Number 2, filing and recording a new TOD deed with a newly named beneficiary duly witnessed by 2 witnesses. Or number 3, selling or transferring the property to someone else before the owner's death. I know this subject can be sad and a little intimidating, but it is really important to take care of your estate so that your wishes are acted upon and so that the heirs to your estate have really clear instructions. For more information on wills, estates, and probates, please feel free to contact me. I'm Shemeika Fox, your Santa Cruz Real Estate expert, and as always, I'm here to help you navigate through the good times and the hard ones.